All right, Brian Osborne, I just brought you in by mistake, so I'm gonna put you back in the waiting room, all right?
Okay, thank you.
Thank you. Okay, so Miss Brenner and Miss Underwood. So Ryan Bates, you want to come up to the podium? All right, this is in the matter of the people, and your attorney's right there. All right, so in the matter of the people of the state of Michigan versus Ryan Matthew Bates, file number 25-22336FH. I have Sarah Brenner appearing on behalf of the AG's office. I have Brenda Underwood appearing on behalf of Mr. Bates. This is the date and time set for a pretrial conference in this matter. Ms. Underwood and Ms. Brenner, how would you like to proceed today?
Your Honor, I believe Mr. Bates was a little light on his payment math last month, and I believe he's going to make that up. I would ask Ms. Brenner to agree to a 60-day adjournment on this matter. And in the meantime, Your Honor, Mr. Bates can continue making payments.
And Your Honor,
Brenner?
he was making really good payment efforts the last couple of months. And then in August, they dropped down, and this month it's been very little. So it looks like he may have had a job change. I don't know what's going on there. I had asked Miss Underwood to find out if there was something going on with his employment. I'm not opposed to giving him more time. I just would like to know what's going on with his employment, since that income withholding.
And I did try to reach out to Mr. Bates. If he would like
Mr. Bates, hold on. Everybody stop talking for a minute. Thank you. Sorry, hold on, because we were all talking at the same time. Mr. Bates, did you switch employment?
There was a job change, that's why.
Okay, so understand, if they don't take the money out of your paycheck when you first start a new job, you got to pay that online, okay? And you've been doing a good job. Miss Underwood's pleased with that, and so is Miss Brenner. But this is probably the time to get that second job. I don't care what it is, doing dishes, something to pay even more down. Do you understand? And I have people do it. I had a guy a couple of weeks ago paid off $17,000 in arrearages on one of Miss Underwood's clients. So it's possible to do. So I'm going to set this out. And Miss Adams, could I get a notice of hearing from Mr. Bates for November 19 at 8:30 in the morning? And do you want Zoom instructions?
I understand how to do that, but I will take it anyway, just in case.
It's easy. You just download.
Pretty easy, yeah.
Yeah, right there is your Zoom instructions. All right, we'll get you a notice of hearing. Have a seat right behind you.
Okay.
And then we'll see you back on November 19 at 8:30 in the morning. Like I said, make those payments online if they're not coming out of your check, and then probably find a second job just to make sure you get this paid down. All right?
Sit down right here.
Yep, just have a seat right there and we'll get you a notice of hearing. I'm going to bring Brian Osborne in. All right, Mr. Osborne, this is in the matter of the people of the state of Michigan versus Brian S. Osborne, file number 25-22344FH. I have Rhonda Underwood appearing on behalf of Mr. Osborne, and I have Sarah Brenner appearing on behalf of the Attorney General's office. This is the date and time set for a pretrial. Ms. Underwood and Ms. Brenner, how would you like to proceed?
Thank you, Your Honor. Mr. Osborne, this is our first pretrial since the case started, Your Honor. Mr. Osborne provided proof of a payment of $1,000 that he made, I think 2 days ago, Your Honor. So I think even though the arrearage is very high, Mr. Osborne is working on it. We would ask for a 60 to 90-day adjournment for him to get even further payments made.
Ms. Brenner?
I don't have an objection to that, Your Honor. He posted a large bond that was applied. So this is an all arrearage case. So I'm just looking for consistent monthly efforts, and then we can look at proceeding with the delay of sentence option for him.
All right. So, Mr. Osborne, the good news is it's not currently charging anymore. What's the arrearage as of today's date? Ms. Brenner, do you have that information by any chance?
Yes, before the application of the $1,000, because that hasn't come through the system yet, it's 26,769.42.
All right, so Mr. Osborne, obviously it's important that you make regular payments on this. Are you currently employed?
Yes.
Okay, excellent. So if they're not taking payments out of your check, you need to be making payments online, or we accept cash in person at the front of the court. And I'm gonna set this over to December 3rd at 8:30 in the morning. And Ms. Underwood, can you prepare the stipend order to
I'm happy
adjourn?
to
Ms.
do
Brenner?
that.
Can
I'm
she
happy
sign your
to do
name with
that.
permission?
Yes, Your Honor, thank you.
All right, excellent. All right, Mr. Osborne, we'll see you back on December 3rd at 8:30 in the morning. Good luck.
Thank you.
Thank you, Your Honor.
Thank you. All right, Clay Sain. Yeah. I don't see him in my waiting room. So in the matter of the people of the state of Michigan versus Clay DeCarl Sain, S-A-I-N, file number 25-22345FH. I have Rhonda Underwood appearing on behalf of Clay Sain, and I have Sarah Brenner appearing on behalf of the AG's office. Ms. Underwood, do you want to call in the court hallway? Mr. Sain is not in my waiting room, and he
Your
is
Honor,
not.
I'm kind of surprised he's not here. He's making very good payment efforts. I believe I talked to him. Let me try to get him.
Well, Miss Brenner, is he making payments?
Yes, Judge.
Do you want me to just adjourn this then?
I'm fine with that, Your Honor. If he fails to appear next time, I would have to ask for a warrant, but I won't today.
All right, so Miss Underwood, I'm gonna set this over to December 3rd at 8:30 in the morning. Can you do the stipend order to adjourn? And Miss Brenner, can you sign your name with permission?
Yes, Your Honor, thank you.
Thank you, Your Honor.
All right, Miss Brenner, is that it?
That's it. Have a great day, Judge.
You too. Thank you, Miss Brenner. Okay, so. Right, do we have MDOC, any information?
I think you said they're gonna zoom in.
All
They
right,
got prints. So they're gonna zoom.
Grenzicki. So Miss Underwood, Grenzicki from MDOC supposedly is zooming in because we did get prints, but they have not zoomed in as of yet.
Okay,
And Miss Underwood, I have, let's see, T-Land Dorsey versus Ephraim Hayward. Mr. Hayward, do you want to come up to the podium? All right, and that's file number 25-52712PP. I have Rhonda Underwood appearing on behalf of Mr. Hayward, and I need a prosecutor, Isaac Sneed, maybe? I don't know, who's my
Yes.
prosecutor on this? Okay.
Trying to get my
So,
camera to work.
It's okay. All right, so this is the date and time scheduled for a pretrial, as well as a motion to terminate the PPO. I have a violation. Let's see. There
Your Honor, I
is,
believe the party wants this dismissed, unless I'm wrong.
well, the party is not here. So,
I got the paper. I was served the paper that she requested,
yeah, she's filed a petition to terminate, but I can't do it unless she's physically here. So, Mr. Sneed, unless you've had communication.
I believe a nole was filed on the criminal case, Your Honor.
Well, I'm here, right, I'm here on the PPO today, but, I'm just asking Mr. Sneed if he's had communication from Miss Dorsey.
No, we have not.
Okay, so you're right, Mr. Hayward. She filed on August 25 a motion to terminate the PPO. That is set for today, but she's not here. So I can reschedule this out a week to see if we can get her here, because I need her to come in and just put it on the record. Okay, so I'm gonna set this out to I'm just gonna set out to September 17. And we'll send a notice of hearing out September 17 at 8:30. And Miss Adams, if we can make sure to write on her notice that she needs to appear on her motion.
Okay.
All right. So can I get a notice of hearing from Mr. Hayward though, September 17 at 8:30? All right, so stay away from her for the next week, okay? Don't go near her until I get rid of the PPO, and I don't know if there's an underlying charge somewhere, but we'll come back next Wednesday at 8:30. So I have a seat right behind you, and we will get you a notice of hearing, all right? All right, Grenzicki. So I think Grenzicki is the last one I have for you, Miss Underwood.
That's correct, Your Honor.
Okay, so, that attorney went out home. I don't know, he was on, I don't know who he was. I think he was on, it might be Mr. Montoya. Okay. Mr. Montoya?
First, good morning.
Oh, who are you here on? Heard.
First,
All right, come on up. Okay, this is in the matter of the people of the state of Michigan versus, you stand right next to you. Yep, Brandon Lee Heard, file number 25-22352FH. Counsel, can you place your name and P number on the record?
Brian Montoya with it on behalf of Brandon Burke, P74163.
All right, and I have Allison Arnold appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So Mr. Montoya, how would you like to proceed today?
Your Honor, I'm going to be asking for an adjournment in mid-October. So we're doing some work as far as some things Mr. Hurd is doing toward assessments and so forth, working towards a resolution. I looked at the calendar, October 15th, if that's available, would be my request.
Yes, so Ms. Adams, I'm gonna need a notice of hearing from Mr. Hurd for October 15 at 8:30.
Your Honor, I do have one other request on the board for that.
Hold on one second.
Sure.
So I'm gonna set this over for another pretrial. Is that all right with you, Ms. Arnold?
It is, Judge.
So October 15 at 8:30. That can be in person or via Zoom. You know that, Mr. Montoya.
I do, and normally I use the Zoom, Your Honor.
I know you do.
He had
Okay.
some other matters at the courthouse this morning, so.
Okay. And then what was your next question?
Regarding bond, Your Honor, and I know I haven't filed a motion on this, and Ms. Arnold, I just learned about this this morning. So that's why I didn't give you any heads up yesterday when we spoke. I'm not requesting any more liberties with respect to bond, but the child's mother is here this morning, and she informed me that what she wants, what the family needs is for the kids to change completely where they live right now, to go live with their grandparents. And that's because the grandparents need to take them to school because of her work schedule. So the only request I have is it's not to have contact, and no contact stays in place. It's just a no go to, because he's currently living at that grandparent's address. So the no go to needs to change.
Is he moving?
Yeah, he's going to move out of their house back to where the apartment where he originally lived, and they're going to live in the grandparents' house because that's what the kids need.
So mom and the kids are moving to grandparents' house and he's moving to the apartment.
Right, so I'm just asking to change the no go to the address of the no go to.
All right, did you get all that, Ms. Arnold?
I did, thank you.
Do the people have a position?
We do not object to that as long as he is not traveling to the house where the children are residing.
Okay,
And that's clear, Your Honor. I do have a new address for you.
so can you write that down on a Post-it note, because we're live on YouTube?
Sure.
And I'll give that to my assistant to make the bond changes.
I appreciate that. Your Honor.
Mhm. This will be the address of the grandparents, correct?
That is correct.
So we'll change the cannot go to this address. All right, here's a notice of hearing, so you won't have to do that. Ms. Adams, here is the updated address with bond or no go to. Yes, thank you. All right,
Your Honor.
you're all set. Thank you, Mr. Montoy.
Thank you, Your Honor.
You're welcome. All right. All right, Mr. Ramsayer,
Good morning, Your Honor.
good morning. So Mr. Harlow or Miss Harlow? No.
It's Mr. It's Burton Harlow.
All right, Mr. Harlow, okay. All right, you don't look like an Andrea, but I'm gonna guess you're Burton, right?
That is correct.
Your screen name says Andrea, sorry. So this is in the matter of the people of the state of Michigan versus Burton James Harlow. File number 25-22276FH. I have attorney Ryan Ramsayer. Which P number, please?
It's P73195, Your Honor.
All right, appearing on behalf of Mr. Harlow. And Ms. Arnold, are you appearing on behalf of the people in this file?
I am. Thank you, Your Honor.
All right, I do have a date, letter dated September 8th of 2025 stating that Mr. Harlow is currently being monitored with a GPS tether, and to date, we have received no violations. I've also received a plea agreement form will your client be availing himself of the plea today, Mr. Ramsayer?
Actually, Your Honor, that's what I was going to discuss. I've spoken with Ms. Arnold about this. We were asking if we could adjourn this to October 8th. Mr. Harlow has some things to wrap up, and we would enter the plea on that date. So if we could set it for a plea date of October 8th, we should be able to go
Okay.
forward with the plea at that time.
Miss Adams, could I get a different time for a plea on this case than October 8th, like maybe in the afternoon or late morning or day before or the next day?
October 8th,
Or the day before or the day after?
we could do October 9th at 11:30.
Are you both available October 9th at 11:30?
That works for me, Judge.
Mr.
Available, Your
Ramsey?
Honor.
All right, so, we will set this over to October 9 at 11:30 via Zoom. Mr. Ramsayer, if you can do the step in order to adjourn, and we will do the plea on that day. Mr. Ramsayer, do you have the advice or rights to have your client fill out and sign?
I don't know if I do, Your Honor. I will get a copy to you.
What's the circuit court file number on those? Advice or rights. So there, it's a new requirement, so it's circuit court scale form MC 291. And if you can just get him to sign it and put it in the mail to us, that'd be great.
Absolutely, Your Honor.
Okay,
I'll
All
do
right.
that step in order this afternoon, and it was okay with your permission, Ms. Arnold?
It is.
Thank you very much.
all right, we'll see you back for plea on October 9th at 11:30. Thank you.
Thank you. Have a wonderful day, everyone.
You
Thank
too.
you.
All right, Sean Carroll.
Good
Oh, you
morning,
have
Your
your
Honor.
client with you. Good. This is in the matter of the people of the state of Michigan versus Jason Michael Duncan, file number 25-22338FH. I have I'm Phoebe McClure appearing on behalf of the people, and I have Sean Carroll appearing on behalf of Mr. Duncan. What's your P number, please?
It's P44452.
Thank you. So this is the date and time set for a pretrial conference in this matter. Mr. Carroll, how would you like to proceed?
Judge, I could just ask the court for some assistance in some matter. I spoke with the prosecutor yesterday. Neither one of us have a transcript, and she referenced that the court oftentimes can enter an order that it be produced.
So we don't automatically order a transcript in this county just because a smaller county. So if
Sure.
you wish to have a copy of the transcript, you have to do a request, and they have 90 days to provide that.
Okay,
So,
well, okay. I did make a request and write a check to the transcriptionist. So I don't know, did I have to have a separate order too, or was issuing
no,
a check to
you
her?
already
No,
did that. So you already did that?
I did.
Oh, okay, so you did a subpoena. Okay,
Yeah.
so,
No. Not for that. I issued her a check to Marissa Adkins.
oh, that's a subpoena for something else, right? Is Marissa?
Yeah,
I think,
that's
Judge,
right.
that we would still need an order, because I think just receiving payment, I don't think that would trigger her to get that to us.
So, is there a scale form number or something?
I
Where
can
does it
prepare
get
an order, Judge. I don't think we're gonna need, if you just tell me what to do, I'll prepare an order and the prosecutor will sign that says they're to produce a transcript within whatever time frame you ask.
90 days. All
Okay.
right, I don't know what the form is, Ms. McClure, Ms. Underwood, Mr. Glazier. I don't request them anymore. So,
Okay, Judge Olsaver always requests them, so I'm not sure.
okay, we'll request it. That's fine. So we'll request it, but understand it'll be about 90 days, okay?
Judge, do you want me to do a step? Because I will. It'll just say that the court is ordering the preparation and distribution of the transcript within 90 days of the order, and I'll have it signed by the assistant prosecutor myself and submit it to you.
That's fine. Ms.
Okay.
McClure, can you sign your name with permission?
Yes.
All right, so, and you can just email that today to us. It'll be September, October, November. Let's go out to December 3rd then.
Judge, I think Mr. Carroll has another request of the court as well.
I do, Judge, and
Okay.
I don't know if I've been trying to get access just by way of background. DHS was involved and interviewed all the family members in this case, a number of which will be witnesses in this case. I've been trying to get access to an unredacted report because I was able to get the family to get a copy, and for some reason they don't want to give me an unredacted report. So I'd like to have a subpoena signed by the court. I've actually had one prepared that I can email to you. In fact, that might be the subpoena that you already have, because I think I'd asked my staff to forward it to you ahead of time, which basically just goes to DHS to provide a copy of an unredacted copy of the report that they prepared in this matter, and any and all supplements that they received. I don't remember exactly what the trooper said, but she said, I filled out a form for DHS as well for this. And then they had some questions of me or something. So they must have something with the state police as well. And then one other thing I have, and I don't think Phoebe has an issue with it too. I think she's going to request it of the detective. There was a DVD that the detective had gathered from the Department of Corrections for my client's place of employment. I just haven't received a copy. And I think she's going to make a request for that.
And I did make that request yesterday after we spoke, Mr. Carroll.
Thank you.
Okay, so I have received the subpoena for that, and I've signed it. And anything else, Ms. McClure?
No, I guess I would just ask Mr. Carroll to whatever he does get from DHS to provide to us, because we've also requested that and not gotten it.
Absolutely, Judge. It's your subpoena. I'm going to make sure everybody gets it. Judge, I don't know. Because I would put a cover letter with it normally when I do these things, because I would say to them, this is signed by the judge, that if you don't comply, my next step would be to set a show cause. Is that okay language with you if they don't give it to us within 14 days?
That's fine.
Okay.
Ms. McClure, any objections?
No objection, and I think I indicated to Mr. Carroll that DHS has their own attorneys that would deal with that. So if they don't comply, that would be on them, not our office.
Sometimes their
And I
attorneys
understand
show
that.
up.
Yeah, I understand. And I don't think we'll have a problem. Normally when it's signed by a judge, they seem to understand that we're going to get the information. And Judge, I don't know if I can have you email that back to me, or if I might have to run somebody down there to get the original back or something, because I'm not real certain if well, actually, if I get a true copy, that should be sufficient, and then we can keep the original subpoena in the file.
Okay. All right, do you want that emailed to you?
If I could, that would be fabulous.
All right, Ms. Adams, I've signed it and put it in the file. So is December 3rd a good date at 8:30 for the next pretrial?
Sounds good to me, Judge. Is it okay with you,
All right.
Madam Prosecutor?
Yes.
All right, obviously, if you have not received the transcripts yet and you want to adjourn that date, just reach out via email to my assistant and we can put it out a couple weeks, all right?
Well, at that point, would we be into January, Judge, only because I know it'd be Christmas time thereafter? I'm hoping to have a little bit of vacation during that time. I don't know for sure if it's going to happen.
Well, yeah, but it might be a week or two. So, you know, it could be the 10th, 17th or whatever. So,
Okay.
All right. So I'm going to set it for December 3rd at 8:30. Do the stip in order to adjourn. We'll get a true copy of the subpoena emailed to you. And is there anything else we need to do?
Nothing further, Judge. Thank you.
No,
All
thank you.
right. All
Guys, have
right.
a great
Thank
morning.
you.
Thank
You too. Bye. Okay, I put a post-it on that. Okay. All right, I do not have MDOC. Mr. Murphy, I have Mr. Rosales in the courtroom.
Your Honor, would he be able to go in the hall and talk to me in a breakout?
Sure, this is in the matter of the people of the state of Michigan versus Isaac Jacob Rosales, file number 25-22346FH. I have Matt Murphy appearing on behalf of Mr. Rosales, and I have Alexander Bayonetto appearing on behalf of the people. So, Mr. Rosales, my bailiff's going to take you, he's also IT now. He's going to take you out in the hallway and connect you to a Zoom device in the hallway. And then I will be able to put you in a breakout room with your attorney.
Thank you.
All right. In the matter of people of the state of Michigan versus Larry Dean Clark, file number 24-22077FH. I have John Glazier appearing on behalf of Mr. Clark and Isaac Sneed appearing on behalf of the people. This is date time set for a final pretrial conference in this matter. Mr. Glazier, is Mr. Clark with you? You're muted, Mr. Glazier.
No, he's not. He's never missed a court date, Your Honor. I don't know if he's aware that this has switched over to your court from Judge Allsavers. This case has been pending since December. You can look at the number of court dates we've had. He always appears, and I believe he's ready for trial.
All right, hold on 1 second. Let me open up a breakout room, Mr. Murphy, with you and your client. All right, so, Miss McGrain, if you could do that, please.
Keep coming.
He's on, but I'm connecting him to, trying to get him to unmute and connect the video. He's not connected. All right, Miss Underwood, I got MDOC coming in. Good morning, MDOC. How are you?
Sorry.
Wait, can you hear us with MDOC?
Stay right here, just move a little closer. Get you hooked up.
Wait, can you hear us, MDOC?
Yep, I can hear you. I can hear you now. We were muted. Sorry. I
All right,
apologize.
thank you.
We had flew aboard this morning, so we're getting him right now. Okay.
Okay, thank you.
Thank you.
All right, and go ahead and click on join that breakout room. Mr. Rosales. Yep, he did. Good. All right, so we're back with Larry Dean Clark. So this is set for jury trial. And so Mr. Glazier, Mr. Clark failed to appear on September 3rd of 2025 in front of Judge Olsaver. He's also failed to appear today. We are going to, Ms. McGreen is logging on to Judge Olsaver's Zoom. So give us a moment to check if he's zoomed in there. So,
Your Honor, I know this morning I was in the waiting room for probably 10 or 15 minutes. I wasn't told that it was being switched over. And so finally, when I called the court, Judge Olsaver's court, they told me, so I switched over. I don't know if the same thing happened to Mr. Clark or not. He may
well,
have
the
very
notice
well
of hearing that went out to you in your office did indicate it was my court for today. But Ms. McGrain's going to check that, so give us a moment. All right, let's
Judge, I sent you a
see.
chat. All
right, no one is in Judge Olsaver's waiting room, and as I said, Mr. Glazier, the notice of hearing that was mailed out on September 3rd did indicate the final pretrial would be held today in my courtroom via Zoom, but I do have a note from Judge Olsaver's court that on September 3rd of 2025, Mr. Clark failed to appear in front of Judge Olsaver as well. So, Mr. Glazier, do you want to try to reach out to him?
I have, Your Honor. I've left a recording on the phone number I have for him. My biggest concern is I don't want to lose the trial date, Your Honor. And I guess
well, Mr. Glazier, I'll give you a couple minutes or this morning's docket to reach him. But if you're not able to reach him, I am going to remove the trial date from the docket because he hasn't appeared the last couple of days. So go ahead and try to reach out to him this morning.
All right.
All right, thank you.
I have.
All right. Miss Underwood, I have in the matter of the people of the state of Michigan versus Jonathan Lewis Grenzicki, file number 25-22359 FH. I have Rhonda Underwood appearing on behalf of Mr. Grenzicki, and I have Phoebe McClure appearing. Wait, who do I have in the MDOC room?
Jonathan Grenzicki.
Okay, I want to make sure, and I have Phoebe McClure appearing on behalf of the people. So, Miss Underwood, how would you like to proceed today with Jonathan Grenzicki?
Could I have a breakout with Ms. Grenzicki, please, Your Honor?
Okay. All right, so I'm going to open up a breakout room, and Miss Underwood, I'm not sure. Okay, there you go. Go join that breakout room. All right, Mr. Murphy still in a breakout room. We're still waiting for that one. Mr. Carroll, did you have something else this morning? Or are you just hanging out?
I did not, Judge. I just was here, just kind of operating on. There was somebody I was going to call later on today, but I was just seeing when she was going to finish.
All right. I got Mr. Barker and Cara Yellott. All right, Mr. Barker, and it's Yellott, right? Is it Yellott? Cara Barker Yellott?
Yes. Good morning, Your Honor.
Okay, I want to make sure I pronounce it right. So you pronounce it, pronounce your last name, Cara.
Barker Yellott. You had it right.
Yellott. Okay. I just wanted to make sure. All right. so this is in the matter of the people of the state of Michigan versus Cara Barker Yellott. File number 25-22270FH. I have Stephen Barker appearing on behalf of Miss Yellott. And Phoebe, are you on this case, Miss McClure? Phoebe McClure?
Yes, I am.
Appearing on behalf of the people. So a couple things. I do not have fingerprints yet on this file. So Miss Barker Yellott, have you gone and had fingerprints taken at Raisin Township?
Judge,
Yes,
she
I
has
did.
been fingerprinted. And if you give me 1 second, I can say exactly when she was. But I do have a supplement that indicates she was fingerprinted.
All right, can you forward that supplement to Miss Adams for me?
Yes.
Okay, if you forward that to
She
Miss
was
Adams.
fingerprinted. I'm sorry, she was fingerprinted at Tecumseh Police Department November 1st, 2024. But I can forward that to you said Miss Adams or Miss McCrane?
Miss Adams would be fine.
Okay.
Okay. All right, so Mr. Barker, how would you like to proceed? This is the date and time set for pretrial, so how would you like to proceed?
Well, she and I spoke yesterday. We were awaiting some information from the officer in charge. My daughter and I met with him to go over with things in terms of trying to get some kind of idea what we're looking at restitution wise and actual number of alleged victims. He was going to send that to the office. He has not done so. I believe sister counsel though has received something from him. So once we have that, then the plan is that we will discuss a potential resolution and a plan for determining restitution and how it's going to be made, which would have to be in very small increments due to her financial condition.
And Your Honor, that document that he's referencing, we did receive that from Raisin Township. It looks like we sent it to Mr. Barker in June, but in our system, it indicates if something was sent or not. And it says it was sent, but it was not downloaded by Mr. Barker. So I'll have to resend that to him. But if I could get Mr. Barker an updated email address for you, because I'm wondering if it didn't go to the correct email address.
So Miss
Actually, I had to change computers because the one I was having was just
everybody
sending stuff.
stop for a minute. Hold on,
Okay.
stop talking.
Yes, sir.
So Miss McClure, if you can chat a request for an updated email address to him, and then Mr. Barker, send your email address to Miss McClure in chat.
Sure.
Because we are
Okay.
live streaming. Okay.
And
Okay.
other than that, Judge, I think we'll be able to come to an agreement on restitution fairly quickly, and Miss Yellott will go through our diversion program. So I think it would be appropriate to go maybe 90 days out to track the progress of it.
Okay, so Mr. Barker, December 3rd at 8:30 in the morning for a pretrial.
Court's indulgence for just a moment, Your Honor.
Sure.
While I look at the book, The Control of My Life. I assume that will be a good date. One more. Yeah, I'm sorry. December 3rd, what time, Your Honor?
8:30 in the morning.
Will this be by Zoom again?
It can be via Zoom, yes.
That would be fine, Your Honor.
So this doesn't mean this is absolutely correct, but I do not have a stipend order from July 16th, scheduling it for today. Like we did the initial notice. Let me see here, back on May 28th for the first pretrial on July 16th. And then we had, I think, a pretrial on July 16th, but I don't have the stipend order adjourning it to today. So, and it may be lost in the system. I'm not saying that, but I will need a stipend order done, Mr. Barker, setting it from today's date to December 3rd at 8:30 in the morning. And Miss McClure, can he sign your name with permission?
Yes,
if Mr.
absolutely.
Barker's okay with it, our office can prepare that.
Yeah, that'll
Okay, so
be
Mr.
fine.
Okay, so Mr. Barker, she can sign your name with permission.
Absolutely, Your Honor.
Okay, All right, so we will see you back on December 3rd at 8:30 in the morning. And Ms. McClure, thank you for emailing that notification of prints to Ms. Adams, and we'll get that over to the clerk's office and track that down. And we'll see you back via Zoom on December 3rd at 8:30 in the morning. Ms. Barker Yellott, what I would tell you is, get one job, get two jobs, do what you got to do so that you can make, acceptable payments on this. And I wish you all the best of luck. Thank you.
Thank you, Your Honor.
And Mr. Barker, don't log out without sending me your email address. I did a private chat.
Okay, let me see if I can find it with my limited computer skills.
Chat is down on the bottom bar. There should be a little icon for chat. If you click on that, it'll either show her chat or it will pop up on the side, and you can click on Phoebe, APA Phoebe McClure.
Yes, sure. I'm doing that right now.
Excellent. Thank you. All right. So Mr. Murphy, Mr. Rosales, you want to come back up? I'll bring MDOC back too as well. Give me just a minute. All right. So Mr. Murphy, how do you wish to proceed today on behalf of Mr. Rosales?
Your Honor, Mr. Rosales had questions relating to the plea offer and what that would entail in this matter. I was going to ask to adjourn. This is the first time up here in circuit court, although the case has been pending for a while down in district, but I'll just ask for one adjournment. Mr. Rosales is going to contact my office about coming in, and we can have a lengthy discussion.
So October 15 at 8:30 a.m.
Yes, Your Honor.
All right, Ms. Adams, could I get a notice of hearing from Mr. Rosales for October 15 at 8:30 in the morning? So,
Okay.
Mr. Rosales, we'll get you a notice of hearing. Zoom instructions are there, right to your right. If you want to appear via Zoom, you can do that as well. Just make sure you download it on your phone and practice in advance, okay? So you have a seat right behind you, and then we'll get you a notice of hearing, all right?
Thank you, Mr. Rosales. I'll see you soon, okay?
And you speak English, right? Yeah, okay, because we have interpreters if you need one. Okay. All right, so, all right, back to you, Miss Underwood. So in the matter of Jonathan Grenzicki, Miss Underwood, how would you like to proceed?
Thank you, Your Honor. And first, Ms. Grenzicki identifies as female, Your Honor. Jalen.
I was going to ask that. So your preferred pronouns are she and her. Excellent. So Miss Grenzicki. So how would you like to proceed on behalf of Miss Grenzicki?
At this time, Your Honor, reviewing Ms. Grenzicki's history and significant medication, I'm going to ask for a forensic as to competency in this matter. And I would be filing that for signature upon presentation.
Okay. So, Ms. Grenzicki, what I'm going to do is I'm going to set this out for a pretrial about 4 months out. We may or may not have a forensic exam report back by that time, but it's just to monitor it. Ms. Underwood, if you can prepare the orders, I will sign those. Ms. McClure, I assume the people have no objection. Okay, I'm going to go with no. So October, November, December, let's go to January. I'm going to set a pretrial for January 7 at 8:30 in the morning. Now, Ms. Grenzicki, obviously, if we get something back sooner, we will bring you back right away. Okay?
Yes, ma'am.
All right. So, Ms. Underwood, if you can do the step in order to adjourn to January 7th at 8:30, I would appreciate it. Thank you.
Thank you.
And Ms. Adams, if you would let me get these pronouns down. And if you want to take this file too. Thank you. You look really nice today. She dresses way more professionally than I do. All right. So,
I all set, Your Honor.
you're all set, Ms. Thank you.
All
You're
right,
all set.
thank you.
Thank you. All right, Mr. Glazier, I do have Christopher Taylor. Want to come up to the podium? All right, in the matter of the people of the state of Michigan versus Christopher Keith Taylor, file number 25-22328FH. I have John Glazier appearing on behalf of Mr. Taylor, and I need a prosecutor, please. I have Isaac Sneed. Who's the prosecutor, Alexander Bayonetto or Mr. Sneed?
I'm not sure whose it is, Your Honor.
Okay.
I think it's
I'm
mine.
gonna go with Mr. Sneed. So this is the date and time set for a pretrial conference. Mr. Glazier, how would you like to proceed?
Your Honor, I need to talk to my client just for a second. We talked in our office, didn't we? I just want to see if he wants to take the plea bargain that was offered to him.
So, sir, I need you to step out the hallway, go to your left, and my bailiff will help you because you got to connect to audio and video. And then I'll put you in a breakout room with Mr. Glazier, okay? All right. Any luck getting hold of Larry Clark?
No, he hasn't. I left a message on his recording.
Okay, we got time. Okay. All right.
Oh, I can talk to him Thursday. No, he's at his office. So I just write it here, okay?
Okay, good. I'm going to open up a breakout room. And so you're going to click on join that breakout room. So let me get you there. Okay, click on join the breakout room. Beagle. All right.
And Judge, I had to take a call from Mr. Barker. He got kicked out, so I didn't get his email address. But I think I missed Grenzicki when I was on the phone.
Brzezinski, they did a request for forensic.
Okay.
And I adjourned it out to January 7 at 8:30. Because we have horrible delays with forensic examinations, so.
Is it going to be for competency and criminal responsibility or just competency?
I think she said both. I mean,
Okay.
they're always
All
for
right.
both anyway, so.
Okay, thanks.
Thank you. I'll be right back in 2 seconds, so you don't need to go if you don't want to. If you want.
Yeah.
Yeah, let me know.
Oh, yeah, I got it, Joey.
I got it. My copy is on this. No.
John, did you just talk to Christopher Taylor?
Yeah, is this your case?
It is.
Ms. McClure, Mr.
Yes.
Glazier, you're on Zoom and the defendant's in the courtroom, just to let
Yeah.
you know.
Okay,
Okay,
thanks.
thank you.
You want me to call you or call me, Phoebe?
I'll call you.
All right.
Please rise, start court's now in session. You may be seated.
All right. Glaziers on the phone. So, hold on, he's talking to probably a prosecutor or something, so. Oh, Mr. Glazier, so back on the record with Mr. Taylor. So how would you like to proceed with Mr. Taylor?
Your Honor, we'd ask to adjourn this maybe just 2 weeks is all. He's indicated he's been trying to get a message to me, but I didn't get that he was trying to get a hold of me. If he goes over today and sets up an appointment, they'll get him in so he can see me. And we're waiting. He's advised me that the victim's going to file some request to have it dismissed. And I've talked to Phoebe about that, and that may not be possible, but at least give her a chance to file them and it'll give me a chance to talk to him.
Okay, so I'll adjourn this to September 24 at 8:30 in the morning. Miss Adams, could I get a notice of hearing from Mr. Taylor?
Okay.
All right, so Mr. Taylor, we'll see back September 24 at 8:30. I would advise you today, you wanted him to make an appointment to come see you?
Yeah, you can walk over there today and set it up, Mr.
Yeah.
Taylor.
So just walk over there today, set up a time and make sure you show up for that, okay? All right, we'll see you back September 24 at 8:30. Have a seat right behind you.
Judge, could I play something on the record?
He's got one. Oh, yeah.
I just wanted to clarify for the record that I did indicate to Mr. Glazier that even if the victim requested dismissal, we may not be able to because a firearm was involved, but that we could continue discussing a resolution based on that. But I wouldn't likely be able to dismiss it because of the firearm aspect. But other than that, I just wanted to clarify that for the record.
Yeah, and I want to
Okay.
explain that. I want to explain that to Mr. Taylor when he comes into my office.
Okay.
So Mr. Taylor's received a notice of hearing. He has his Zoom instructions and we'll see you back on that day. Thank you. You're welcome.
All right.
All right.
Thank you, Your Honor.
You're welcome. Mr. Glazier, any luck locating Larry Clark in the matter of the people of the state of Michigan versus Larry Clark?
No, I have not.
Okay.
I haven't heard anything back.
You guys have like an investigator go out to his house or something? Because
I
I
couldn't
don't
hear
know.
you.
Do you guys have an investigator you can send out to his house and try to locate him?
I thought about that, but I can't do it right now.
Okay. All right. I think I have, let me see.
I didn't know he missed a date. I don't think I was present for that one. You said September of when?
Mr. Malaro was there.
Mr. Malaro appeared on your behalf and it was September 3rd. So he failed to appear for the last pretrial as well as this one. And hold on a second. Let's see. Let's see here, September 3rd. Yep, and a notice was mailed out to appear in front of Judge Olsaver for that day. And then there also was the criminal scheduling order that had that date as well. So I would assume your client received both of those. So he failed to appear September 3rd and today.
Yeah, I wasn't aware of that. Right?
It's okay. So if you haven't reached him by 11, I'm going to set the trial date off and then you can deal with that with Judge Olsaver's court.
Absolutely.
Okay.
I left a recording and if he calls me before 11, I'll let you know as soon as I hear something.
Yeah, we still have a couple things, so we will be on the record till then. So just let us know. We'll zoom back in. All right. I
have one more with you, I think.
Yep. So in the matter of the people of the state of Michigan versus Jeremiah Richard Beagle, Mr. Beagle did appear in person last time in the courtroom. I do show that we did proof service for today's date for Mr. Beagle. And then I have received a forensic report for competency to stand trial. I do not have Mr. Beagle. He is not in the courtroom or the hallway or via Zoom.
Your Honor, Mr. Beagle called, at least according to my secretary, called our office this morning, said he can't get a ride to court, and he was told to call the court. We're still waiting for a criminal responsibility on this anyway. If the court wants to issue a warrant.
Okay, we do have to put the forensic on the record for competency though. So are you prepared to do that today?
Yeah, I'm fine with that, sure.
All right, because Ms. Adams, this wasn't placed on the record, right?
I didn't know if you wanted to wait for the criminal responsibility to come in or not.
Well, we only have a certain period of time to put the competency on the record after we receive it.
Yeah, Judge, I don't see that we did.
Yeah, so we have to put the competency on the record. Are you fine putting that on today without your client present?
Yes, I am, Your Honor.
All right, so Mr. Bandetto, the competency is dated July 31 of 2025. Did your office receive a copy of that?
We did, Your Honor.
And then Mr. Glazier, your office also received a copy of that?
Yes, I did, Your Honor.
All right, do you stipulate to entry of that report, Mr. Bandetto?
Yes, Your Honor.
And Mr. Glazier?
Yes, Your Honor.
All right, so this court did receive a report on competency to stand trial. It was signed by Philip May, psychologist, consulting forensic examiner. In this report, the psychologist did find that Mr. Beagle appeared capable of understanding the nature and object of the proceedings against him and assisting in his defense in a rational manner. Subsequently, although the ultimate decision in this depends on a judicial determination, was the opinion of the examiner that Mr. Beagle was competent to stand trial. Mr. Glazier, would you agree that's findings of this report?
Yes, Your Honor.
And Mr. Bandetto?
Yes, Your Honor.
All right, and then Mr. Bandetto, I'll need an order. I think the prosecutors prepare the order on the finding of competency and that public defenders typically do the request for competency. Is that correct still?
I'm not sure, Your Honor, but if we do, I will I'll get those over to the court.
That's
yeah,
how
I've
it
never
always
prepared an order. Your
Yeah,
Honor.
that's how it's always been. So Mr. Bandetto, if you can prepare an order on competency, I will sign that. And then obviously we're waiting on the criminal responsibility. And I will set this out, let's see, for another pretrial. As I said, Mr. Beagle typically has appeared in person. And he did receive notice and he did call. He lives out of city, so, and he doesn't drive. So it's too far to walk from where he lives. So I'm going to set another pretrial for October 22nd at 8:30 in the morning. And Mr. Glazier, can your office do the stip in order to adjourn?
Sure.
And Mr. Van Nettle, can you sign your name with permission?
He can, Your Honor. Thank you.
All right, so Mr.
Your
Glazier,
Honor.
just, yeah.
I don't know if the court wants to send a letter saying you still need he didn't mention anything about the criminal responsibilities. A lot of times we get that saying, well, it's going to be delayed for a little while. And I didn't see that attached to this one.
Let
And
me, hold on,
There,
let me
there
look.
was a memo sent regarding that in June.
oh, there was saying that what?
There
they weren't
was.
gonna take longer on the criminal responsibility?
Yes.
Okay, I didn't see that. That was sent separately. All right. Yeah, we're fine then,
Okay.
because I gotta have
All right.
that. My client wants to have an independent done at some point.
Okay, all right, so you'll do the step in order to adjourn. Mr. Glazier,
That's all I have with you this morning. Your Honor.
so on Clark, Mr. Glazier, it's 9:30 p.m. He was ordered to appear at 8:15. We hold bench warrants for 48 hours. Do you want me to give you to tomorrow morning at 8 o'clock to have contact with him?
Yeah, that's fine.
So
Tomorrow at 8?
well, by the end of
may have-
today's date. Mr. Sneed, is that your case? Oh, Mr. Beagle just logged in.
Who did?
Mr. Beagle, hold on.
Oh, okay.
Mr. Beagle, I'm gonna send you a request to unmute your device.
Okay, can you hear me?
Yes, I can. So, Mr. Beagle, we did call your case and we're waiting on one more report. We placed competency on the record and the doctor did find that you were competent. So I am setting this out for another pretrial on October 22nd at 8:30 in the morning, okay?
Okay,
All right, and make sure you stay in contact with Mr. Glazier.
okay.
Okay, thank you. So you're all set, Mr. Beagle. Thank you for logging in.
All right, thank you very much.
All right, Mr. Sneed, obviously, Mr. Clark is a Judge Olsaver file. As I said, he failed to appear for the last pretrial. We do have a notice of hearing for the September 3rd pretrial, both in a criminal scheduling order and a notice of hearing that would have been sent to Mr. Clark. And the notice of hearing would have been sent directly from Judge Olsaver's office. I'm sure the scheduling order was mailed to him through Mr. Glazier's office. He failed to appear September 3rd. And then his a notice of hearing was sent out for today's date in front of me. And I know that Ms. McGrain logged in to Zoom in Judge Olsaver's and Mr. Clark failed to appear there. As I said, the notice of hearing for today clearly stated it was in front of me. So I can issue a bench warrant and we have to hold the warrant for 48 hours. But at this point, if we don't hear from them by tomorrow morning, I feel like I have to call off the trial.
Yeah,
Your Honor, I'd like to vacate the trial today. I'd like to have more than 2 days notice to give to the witnesses and the police officers that would have to come in and testify. So I have no problem holding the warrant for 48 hours, but he hasn't appeared now on 2 occasions for which we presume he had notice. And I think it would be economical to just vacate the trial date at this point. It's a possession of meth case. So
So Mr.
not gonna
Glazier,
take
I would
long.
make the trial date a final pre-trial or a pre-trial date for him to appear.
Whatever the
All right.
court wants to do. I'm just saying
All
I
right.
could he's got a local address, and as soon as I get back in the office, I can have the investigator go by his house. He's here in Adrian, or at least that's the address I got. But whatever the court wants to do is fine.
All right, so I am going to issue a bench warrant for failure to appear. As we said, we are required to hold those for 48 hours. So obviously, Mr. Glazier, if you get a hold of him, we can bring him in tomorrow.
Okay.
So if you have not heard from, if you're not able to locate him as of 2 p.m. today, I will cancel the trial and set that for pre-trial. What's your name? Well, look who just strolled in the door. Mr. Clark, you want to take your hat off? Go ahead and put your belt on.
Sorry.
It's okay. Yep, come on up to the podium. Okay, so Mr. Glazier, your client did come in. So this is in the matter of the people of the state of Michigan versus Larry Dean Clark. As I said, I have John Glazier appearing on behalf of Mr. Clark and Isaac Sneed appearing on behalf of the people. So you obviously received a message from Mr. Glazier's office.
No, I just woke up. I'm sorry.
You just woke up?
Yeah.
For court? At 8:15?
Yes.
Okay. So Mr. Glazier, I am going to order a drug test today through Mr. Coast. But this matter is, this is the final pretrial conference. So Ms. Adams, could you have Mr. Coast test him?
Judge, I'm sorry, Mr. Coast is off today.
All right, Ms. Walsh, are you in the building today?
Yes, ma'am.
Could you have a male over there or somebody test for me, Mr. Clark?
Yes, I will have, I will come over and grab a test from Mr. Post Office.
Okay, thank you. You're the best. Thank you. All right, so trial is scheduled in this matter for September 16 and 17. Motion deadline was August 27, which has passed. Motion and limines were set for today. I don't have any set for today. Jury instructions were due on September 3rd. Ms. McGreen, are you aware that we received jury instructions? Ms. McGreen may not be in the office. So Mr. Sneed and Mr. Glazier, have your jury instructions been submitted?
We're not requesting anything other than standard instructions.
Oh, did you provide those?
Standard instructions, I never provide those. If I have something other than standard, I provide them.
Okay. Mr. Sneed?
Yeah, I was under the impression we were going to resolve this case. I would like to have Mr. Clark testify before we proceed with the pretrial conference.
So, Mr. Glazier, I know that you're talking about standard instructions, but usually we just get them all stipulated. So that's what I was assuming. All right. And then have voir dire questions been submitted, Mr. Glazier?
I don't have any voir dire questions, Your Honor.
Okay. And Mr. Sneed? All right.
No, they have not.
Okay. So, Mr. Clark, trial starts at 9 o'clock. That means you got to be here by 8:45, 8:30. Do you understand?
I understand.
All right. So I'm going to ask you to go with Miss Walsh, and she's going to have you tested real quick. All right. We'll be just a minute on that. All right, Mr. Brandt, you were set for, let me see. 9:30. Ms. Bruggeman, you're appearing on Hill.
Yes, Your Honor, sorry, I couldn't unmute my device.
Hi, I called the wrong floor. Sorry.
That's okay.
Bye.
Morning, Your Honor.
Good morning. I am ready for Rodney Hill.
Mr. Hill, you got it.
All right, thank you.
Uh-huh.
Bye.
Bye-bye.
Your Honor,
Yes, sir.
I was just gonna let you know, I think Mr. Brandt looks a little like Albert Einstein with his hair out like that.
But he tells me he's smarter than Albert Einstein.
He and I know each other from Jackson. He's a good guy. I just would put in a good word for him.
The question is, who has the longer hair now? And I no longer
Well,
have the longer hair.
I started growing mine when I saw how you had yours. I'm following you.
We have evacuated the Jackson County Courthouse because there's a gas leak. So I'm sitting in my vehicle outside the courthouse waiting to see if it's going to open.
Maybe it's going to blow
Oh my
up.
gosh.
Yes, they have a gas leak in the building.
Well, you're not going to have court today.
I don't think so. So we're waiting for word.
All right. And Ms. Walsh, what case are you here for? Oh, you're just monitoring all morning?
Yes, yes. Doing arraignments. Just a little late to the show.
It's okay. You're gonna need a copy of my docket.
I have it.
I mean, filled out.
I think Becky said there was have not been any pleas, so I'm good.
Not one.
There's been one?
No, not one.
Okay. Then I'm good. Thank you. Mr. Clark is not able to go, so I don't know how long that will be.
All right, well, he and his shy bladder can hang out for a while. So we'll just wait.
Okay.
I only got till 1 o'clock, Your Honor.
Well, you probably want to bring him some water. Or coffee or something. All right. We are just waiting for Mr. Hill. Hill. Okay. um, Oh, there we go. My video wasn't working. All right, this is in the matter of the people of the state of Michigan versus Rodney Lamont Hill, file number 24-21703FH. I have Alfred Grant, P38586, appearing on behalf of Mr. Hill. And I have Jennifer Bruggeman appearing on behalf of the Lenawee County Prosecutor's Office. So, Mr. Brandt, this is your motion. You may proceed.
Thank you, Your Honor. Your Honor, we filed the motion pursuant to statute, which indicates that the court has the discretion to reduce jail sentences based upon certain criteria. We provided the court with what we believe are behaviors evidenced by Mr. Hill at the jail, which provides the court with a basis for reducing his jail sentence by 25%. I am unaware of anything outside of what we filed, no problems, no misconduct tickets I am aware of as of the time we filed the motion. And I talked to Rodney, I think yesterday, and I don't think there's anything that's occurred since we filed the motion. So what we're asking the court to do is at least consider him today for that 25% reduction.
Okay. Ms. Bruggeman?
Yes, Your Honor. I filed an answer to the motion, and I would pretty much rely on that, but just reiterate to the court, as I did in the answer, that one, this motion, or Mr. Hill's only been in jail for about 4 months. He received a very generous Killebrew plea agreement to 1 year in jail. His guidelines were 19 to 38 months. He's fourth habitual offender. And that was obviously dismissed as part of the plea, along with another count. And, you know, quite frankly, again, the allegations, while they indicate what he has done in jail, and I have no reason to dispute it, I also have nothing to substantiate it other than that it's written in the motion. So the bottom line is Mr. Hill will be getting good time credit as a result of doing the things that he's required to do as a jail inmate, and if he does that, great. But really, in this case, there's nothing that he has indicated that really should allow for a further reduction of his already greatly reduced sentence. So I would ask that the court deny the motion.
All right, anything else, Mr. Brandt?
Your Honor, I can speak to the prosecutor's concern in that the statement that my client's done 4 months of a 1 year sentence. And I did talk to Mr. Hill about that Judge Wilson in Jackson will consider these, but his now off the record rule is that my clients have to do half of their jail sentence before he considers the 25% reduction. And I understand that. So what he does is he holds it until after 6 months are in. So I understand the prosecutor's concern that this was early into a 1 year jail sentence. If the court feels uncomfortable today, as I indicated to Mr. Hill, I could refile it after further time period if the court feels it's, if you will, premature.
Right, first, court has no idea who Judge Hill is. I've not yet met him. I'm sure I will.
I'm sorry, Judge Wilson. Judge Wilson, yes, but it could be Judge Hill.
Okay. So in this case, Mr. Hill up until the time that he entered the plea was compliant with his bond conditions, maintained employment, had a supportive family and a stable home environment. So all of these things, including his employer who promised him a job to continue when he was released from jail, existed at the time of the plea and at the time of the sentence. Mr. Hill, again, I understand and I appreciate that he's done well in jail and has worked hard and he's doing the things he's required to do. Mr. Hill has always been very good at, being compliant and doing what needs to be done and taking responsibility for the things that have happened. But while the court does agree this is premature, given that he has served less than that time period at this point, all of these factors did exist at the time the plea was entered. Mr. Hill received a Killebrew plea based on his behavior and his conduct that greatly reduced the prison term that he was potentially looking at. And the Killebrew was for 1 year in jail. And in fact, this court had adjourned the sentencing date out at the request of both the prosecutor and Mr. Brandt to allow Mr. Hill to take care of things that he needed to take care of. I calculate with good time, he'll do 10 months. He's about 4.5 months in. So he's on his way to completing that. But in light of that, I don't think there's a basis for a reduction at this time. So thank you. And Mr. Hill, good luck to you. Thank you.
Thank you.
Thank you, Your Honor.
Well, Mr. Glazier,
Are we on the record?
yes.
Oh, hold on. Okay.
I guess we're waiting on a shy bladder. So I'll have my bailiff go or check on how that's coming along. And I'll let you know. So hopefully
right.
we have something shortly.
That's right. I got work I'm doing on here.
All right.
Unless you're, are you staying?
I'm gonna walk off the bench for a minute.
Okay.
Co-host, so she just lets me know.
No. That's nice. It's like the three kings. And the wise men. Oh, yeah. I should
Complete
have.
opposite.
Oh, okay. Oh. Good morning. How are you, my friend?
Good. How are you?
Good, good. Oh, I like your dress. You always look so nice.
I like your dress.
Oh,
those are great
Oh,
colors.
thank you. I appreciate it, Allison. You're doing well?
Yeah, really good. Yeah.
Good. And your daughter's doing okay?
Yeah, we just finished all of her, I helped her with the letters, like the statements for her residency for vet school.
Yeah.
So she's hoping to do a residency in pathology.
Really?
So she applied to 9 schools.
Uh-huh.
So they'll start doing interviews and stuff, but
Oh, good.
they're pretty, most of them only have 1 spot.
Uh-huh.
So if she doesn't get one, worst case scenario, she just goes and is a vet for a while.
Yeah, there you go. There you go.
So-
So
Yeah.
where are these opportunities? All over the US or?
So there's Washington State, LSU, where she is now, Minnesota, Auburn, which is in Alabama.
Okay.
Georgia, North Carolina State, Michigan State, Minnesota, and Tennessee.
Oh, wow.
So that covers.
It does cover, yeah, from one end to
Yeah.
the other.
Yeah.
Oh, wow, that's exciting.
So they would, the only one, so LSU would be the same distance.
Mhm.
Washington State obviously would be really far.
Yeah,
Everything else is closer.
right.
Yeah.
Good.
Tennessee and Georgia and Alabama, I think are all like 10, 12 hours away.
Uh-huh.
And then I think Minnesota's like maybe 7 or 8.
Okay, okay. Does she have a preference, Allison?
I think she would prefer either Michigan State or Wisconsin.
Okay, okay. And Wisconsin's not bad.
No,
mean,
I think Madison's like 5 or 6 hours.
Yeah, yeah. Oh, good. Well, do you believe that she's at this stage now? I mean, she's
Crazy.
Yeah.
She takes, so for vet school, instead of like how we take the exam after we graduate,
Uh-huh.
they take it before they graduate.
Oh, really?
Yeah, she would still graduate even
Uh-huh.
if she doesn't pass the test.
Uh-huh.
But they can take the test beforehand.
Okay,
So
gotcha.
she's supposed to take the test
Uh-huh.
October 21st.
Oh.
I vote for Wisconsin.
Yeah, Wisconsin would be good.
Yeah,
I'm
that's not
I'm
bad.
anti-Sparty, so I'm voting for
Oh,
Wisconsin.
that's true. Yeah, I should have known, John. Should have known that.
Madison's supposed to be a great town. I've never been there, but I've
Oh,
heard
it
it's-
is. It's a wonderful place. My ex-son graduated from Michigan State. I disowned him after he graduated.
Well, John and Allison, you know who's in Wisconsin is Laura Schwartz, Laura and Matt Schwartz's son, their youngest, Jacob.
Oh,
That's
really?
where he's going to dental school.
I've been up there 3 or 4 times for games and spent the weekend up there. It's just a wonderful place, and I'm not because I hate Michigan State. I'm just saying Wisconsin is a really nice town.
Yeah,
and
I think
atmosphere.
I'd rather live there. East Lansing's a little boring. I don't
Yeah.
love it.
Yeah, it's Wisconsin's something else. I've always had a good time up there.
That's great. So which son did you disown?
Ryan,
Right? Oh my goodness.
Ryan and his wife both graduated from Michigan State.
Really?
Oh yeah, it's you know, one time Annette painted our front porch green and white, and my dad wouldn't go through the front door. He'd always go to the back door.
Oh, that's funny. Oh, my gosh.
Sorry to butt in.
Yeah, right. No, you're fine, John. You're fine. Oh, that's interesting.
Well, she went to Ohio State undergrad, John, so.
Yeah, but see, I'll root for Ohio State when they play Michigan State. That's the only time I'll ever root for Ohio State.
So Joanne, since she's been so busy with this test and her applications, we have her dog, but she's taken back.
Please rise for court style session.
You guys know we're live on YouTube, right?
What?
Oh,
I didn't notice.
We've seen.
all right. I heard everything you said about me.
All good things.
All right, Mr. Glazier.
Yes.
With Mr. Clark, he still has shy bladder and wasn't able to produce enough saliva, so they're gonna give it one more go. So give us a few more minutes.
Saliva's the
All right.
problem.
Shy bladder, but then also he wasn't able to produce enough saliva for a swab. So we'll give him a few more minutes.
All right.
Okay. Have somebody from the jail, if you can unmute and start the audio for us. All right, Mr. Burke, is that you?
Yes.
Okay. This is in the matter of people of the state of Michigan versus Joshua Jordan Burke. We have 3 files, 24-21878FH, 24-21879FH, and 24-21880FH. I have Allison Arnold appearing on behalf of the people, and I have Katerina Dumont appearing on behalf of Mr. Burke. This is the date time scheduled for a competency hearing in this matter. I'm actually gonna sit down now. So hold on just a second, let me get this. All right, so I have received a copy of, well, that's a different one. I have received a copy of a report dated August 12 of 2025, signed by Aaron Serezny, licensed psychologist, consulting forensic examiner. And you received that, Ms. Arnold?
I did.
Ms. Dumont?
Yes, Your Honor.
Okay, excellent. I've also received People's Exhibit 1, which is, well, they're all People's Exhibit 1 for each file. So I have People's Exhibit 1 on each file, which is a felony information. Hold on, let me get back there. And a copy of a police report for each file. You received those, Ms. Dumont?
Yes, Your Honor.
Okay, very good. So, Ms. Arnold, did people stipulate, have we already placed competency on the record?
He is, no, I don't believe.
Okay, so Ms. Arnold, do you stipulate to entry of the report dated August 12 of 25 regarding competence to stand trial?
We do, Your Honor.
Ms. Dumont, do you stipulate to entry of that report as well?
Yes, Your Honor.
Okay, all right. Can I review that report then?
Yes, please.
All right, and then make the findings on that report. Okay, so Mr. Burke was evaluated on August 12 of 2025. He is a 33-year-old man born on October 15. He was charged with home invasion, first degree, second degree arson, assault with a dangerous weapon, jail's possession of a weapon, and assault of a prison employee, and 3 counts of police officer assaulting, resisting, and obstructing on the 3 files that he is currently before us. It was a request by the defense for an examination regarding competency, and Mr. Burke was cooperatively engaged in the evaluation according to Dr. Serezny. There was no behavior indicative of an intellectual disability or other cognitive, psychological, or psychiatric issues that impeded his adjudicative capacities. In the doctor's opinion, Mr. Burke was aware of the accusations against him, how they arose, and considered his defense options with reasonable expectations. Mr. Burke understood how the court works, the role of primary legal counsel, his defense options, possible outcomes, and clearly was able to voice his preferences. And Dr. Seresny found that in their opinion, Mr. Burke was able to understand the nature and the object of the proceedings against him and rationally assist in his defense. Therefore, they opine that he is competent to stand trial. So the court does find that Mr. Burke is competent to stand trial. Correct?
Yes, Your Honor. Does the court have orders for all 3 files? I know the one was prepared in my file, and
I don't have the orders, but I'm assuming I will get them.
Yeah, actually, I can email them right now. It'll take just a second because I have to pull up Mr. Sneed's file. Okay. Hang on. Okay, I sent one for file 880.
Are you sending those to Miss Adams or?
I am.
Okay. So Miss Adams and Miss Arnold will be sending the orders, one for each file on Mr. Burke. We'll need 3 copies of each one to sign. So we'll need 4 total. Of each one.
Okay, there's 879.
You can approach Ms. Walsh. No. And see, all right, so I'm going to pause everybody for a second. Mr. Sneed and Mr. Glazier. So Mr. Clark, why don't you come back up to the podium? Mr. Clark. Okay. So we're back on the record in the matter of the people of the state of Michigan versus Larry Dean Clark. Ms. Walsh, if you can go over and stand by that microphone over there by the jury box for me real quick. All right, so Mr. Glazier, Mr. Clark was unable to provide a urine sample. Probably a good idea if you can to have a urine test done today, Mr. Clark. But Ms. Walsh, you administrated an oral swab, is that correct?
Yes.
And what were the results of that oral swab?
It's positive for methamphetamine.
All right, so at this time, Mr. Glazier, your client is positive for methamphetamine. I do understand that you have a trial scheduled for next week, is that correct?
I believe so, yes.
All right, so and one of his bond conditions is he's not to use any illegal controlled substances. So in light of the fact, I do not want your client showing up for trial under the influence of any illegal controlled substances. I am going to remand him to the custody of the Sheriff's Department. That way I know he appears on time for trial as well as able to prepare with you. So, all right, and I'll set his bond at $25,000 cash. All right, so thank you, Ms. Walsh, and you are ready to proceed to trial then. Thank you.
Yes, I'm ready to proceed to trial, Your Honor.
All right, thank you. Then you can take them down or whatever you choose.
That's all I have with you this morning, Your Honor.
Yes, sir. Thank you, Mr. Glazier.
Thank you.
All right, so we're back with Mr. Burke. So was there a criminal responsibility report?
There was, Your Honor, that found that Mr. Burke is not criminally responsible in all 3 files. It's my understanding he wishes to enter a no contest plea to being not guilty by reason of insanity in all 3 files. And I do have copies of settled record in each file for the court, which would contain exhibit number 1, which is the felony information for each file. Exhibit number 2 in each file would be the police report, and exhibit number 3 would be the criminal responsibility report dated January 27, 2025, also authored by Aaron Serezny, a licensed psychologist from the Center for Forensic Psychiatry. And I believe Ms. Dumont will stipulate to the entry of all those exhibits to support the plea.
Is that correct, Ms. Dumont?
That's correct, Your Honor. And I did meet with Mr. Burke at the Lenawee County Jail, and I advised him of that MGR.
But the original exhibit stickers?
Are those original exhibits?
Yeah.
Okay. Ms. Fay, do you want these? Okay,
Thank you.
I'm gonna rotate around. All right, excellent. So Mr. Burke, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so I'm gonna need you to speak up a little bit louder for me. Can you repeat your response again?
Yes.
All right, excellent. Can you state your full name for the record?
Joshua Jordan Burke.
Okay, so, all right, so Ms. Dumont, your client is today going to enter a plea of no contest?
Correct, Your Honor. That's what we
And then
discussed.
there will be a finding of not guilty by reason of insanity, correct?
Yes, he would be entering no contest plea to that.
Okay. All right. So, Mr. Burke, you've had an opportunity to speak with Ms. Dumont. She stated she came and saw you and you've had time to speak with her. Is that correct?
Yes.
All right. Are you satisfied with Ms. Dumont as your attorney and the advice that she has given you?
Yes, so far.
All right. Now, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest? And I think we phrase it to a plea of not guilty by reason of insanity on each of these files. And which counts is he going to be pleading to?
There's all counts in the file.
All counts, but no habitual offender?
No.
No habitual offender. So that would be count 1 and 2. Count 1, 2, and 3. Let me look, hold on, and count 1, 2, 3. So, all right, so Mr. Burke, do you understand that on file number 24-21879FH, you're going to be pleading no contest to a plea of not guilty by a reason of insanity to count 1, jail, possession of weapons in, which carries a maximum penalty of up to 5 years in prison and or a $1,000 fine. Count 2, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine. The habitual offender 4th offense notice would be dismissed. On file number 24-21878FH, you'll be entering a plea of no contest to a not guilty by reason of insanity to count 1, home invasion 1st degree, which carries a maximum penalty of up to 20 years in prison and or a $5,000 fine. Count 2, 2nd degree arson, which carries a maximum penalty of up to 20 years in prison and $20,000 or more restitution. And count 3, assault with a dangerous weapon, felonious assault, which carries a maximum penalty of up to 4 years in prison. And then on file number 24-21880, you'll be entering a plea of no contest to a not guilty by reason of insanity to count 1, police officer assaulting, resisting, and obstructing. Count 2, police officer assaulting, resisting, and obstructing. And count 3, police officer assaulting, resisting, and obstructing, all of which carry a maximum penalty of up to 2 years in prison. So do you understand, and is that your intention to plead no contest to a not guilty by reason of insanity on each of those files?
Yes.
Okay. And again, you're satisfied with Ms. Demont as your attorney and the advice that she's given you?
Yes.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Arnold?
That's correct.
In terms of what will happen with the forensic center?
Yes, Your Honor, and I'm happy to put the factual basis on all the counts too, just so you know.
Yeah, okay. So you understand, and the process for this would be, once the plea is entered, it would be processed through the Forensic Center for the State of Michigan. Is that correct, Ms. Arnold?
Yes, Your Honor.
So we have no determination, Mr. Burke, on how long you would be placed with the Department of Corrections at the Forensic Center, or what the outcome of that placement in the Forensic Center would be. Do you understand that, Mr. Burke? That would be up to the staff of the Center for Forensic Psychiatry. Do you understand that?
Yes.
Okay. Anything to add to that, Ms. Arnold?
No.
And Ms. Demont, anything to add?
No, Your Honor.
So this court has made no promises to anybody about what will happen there, because it would be under the authority of the Center for Forensic Psychiatry. Do you understand that, Mr. Burke?
Yes.
So if a no contest plea to not guilty by reason of insanity is accepted, there will be no trial. This means that you'll be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Burke, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, Mr. Burke?
Yeah.
Do you understand that any appeal from the conviction and sentence, what?
You said no.
Oh, do you understand that? If you had gone to trial, you would have had an automatic right to appeal to the Court of Appeals, but by entering a plea, you don't have that automatic right. Do you understand that, Mr. Burke?
Yes, I said yes.
Oh, okay. I thought you did. Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Do you understand that if the plea is accepted and you engage in any misconduct, this doesn't really apply to you, but do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. And Ms. Adams, can we make sure the jail gets a signed copy of the advice of rights from him? Mr. Burke, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, Mr. Burke, about the rights that I've given to you?
No, Your Honor, I do not.
Okay, so I think it would be phrased, Mr. Burke, so you're going to be entering a no contest plea to not guilty by reason of insanity. So I think your response on this one would just be either, well, no contest, if that's what you wish to do, okay?
Thank you.
Okay, so how do you wish to plead to the charges that on or about February, and this is going to be file number 24-218788FH. How do you wish to, let me make sure I got all these right. Okay, on file number 24-218788FH, how do you wish to plead to the charge that on or about January 11 of 2023 in Madison Township in the county of Lenawee, that you did commit the offense of home invasion first degree. No contest to, but
No.
not guilty by reason of insanity?
Yes.
Okay, and how do you plead to count 2 on that same date and time and venue to second degree arson?
Same.
Not guilty by reason, or no contest to not guilty by reason of insanity, is that correct?
Yes.
Okay, and then on count 3, assault with a dangerous weapon for that same date, time, and venue. How do you plead on that one? Not guilty by, no contest to not guilty by reason of insanity?
Yes.
Okay, I'm sorry, that's just a mouthful. I apologize. All right, and then we're gonna move on to file number 24-21879FH. So Mr. Burke, how do you plead to the charge that on or about February 7 of 2023 in the city of Adrian, in the county of Lenawee, that you did commit the offense of jail's possession of a weapon in, do you wish to plead no contest to not guilty by reason of insanity on that file?
Yes.
And then on count 2, assault of a prison employee, do you wish to plead no contest to not guilty by reason of insanity on that file?
Yes.
All right, and let's move on to file number 24-21880FH. Mr. Burke, on that file, how do you wish to plead to the charge that on or about December 28 of 2023 in Dover Township in the county of Lenawee, that you did commit the offense under count 1, police officer assaulting, resisting, and obstructing? How do you wish to plead to that? Do you wish to plead no contest to not guilty by reason of insanity?
Yes.
Okay, and on count 2, police officer assaulting, resisting, and obstructing, how do you wish to plead to that one? Do you wish to plead to no contest to not guilty by reason of insanity?
Yes.
And then on count 3, the same charge, police officer assaulting, resisting, and obstructing. How do you wish to plead to that charge? Is that also a no contest to not guilty by reason of insanity?
Yes.
Now, Mr. Burke, you understand your options were on all of these to plead guilty, not guilty, or the no contest to not guilty by reason of insanity. Is that correct?
Yes.
And on all of these counts, on all 3 files, your choice was to plead no contest to not guilty by reason of insanity.
Yes.
And Mr. Mott, was that due to mental illness, lack of memory?
Mental illness and lack of memory.
Okay. And is that correct, Ms.
Yes.
Arnold? Okay. So, has anyone made any threats or promises to you to induce you to plead no contest to not guilty by reason of insanity on any of these files, Mr. Burke?
No, they haven't.
All right. Do you understand that if I accept these pleas, you will be giving up any and all claims that your pleas are given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest to not guilty by reason of insanity? Ms. Arnold?
No, Your Honor.
And Ms. Dumont?
No, Your Honor.
All right, so Mr. Burke, we touched on this lightly already. Obviously, the authority of what happens to you once you go to the forensic center is within their purview. So your attorney hasn't promised you any particular sentence or estimated how long that term would be or what will happen there, has she?
No.
Okay. And is it your own choice to enter all of these pleas to no contest to not guilty by reason of insanity?
Yes.
Okay, so Ms. Arnold, I have felony information for each file as well as the criminal responsibility report. So do you want me to make findings on the criminal responsibility?
Judge, I can put it all on the record quickly.
Okay.
Rather than contest plea.
Okay.
There was a report authored January 27, 2025 by Aaron Sorezny, who is a doctor of psychology, a licensed psychologist and consulting forensics examiner there. He spoke with Mr. Burke, spoke with his attorney, reviewed all the police reports as well as several mental health records. He authored a comprehensive report of all his findings relative to all the charged offenses, and his criminal responsibility opinion stated, "It is my opinion Mr. Burke was mentally ill at the time of all 3 alleged instant offenses. It is also my opinion as a result of his mental illness, he lacks substantial capacity to appreciate the wrongfulness of his conduct and conform his conduct to the requirements of law. It is therefore my opinion Mr. Burke does meet statutory requirements for defense of insanity."
All right, and Ms. Demont, you also received that report?
Yes, I have, Your Honor.
Okay, and you also agree that he was mentally ill at the time of the offenses, and as a result of that, he lacks substantial capacity to appreciate the wrongfulness of his conduct and conform his conduct to the requirements of the law?
Correct.
All right, so the court will find then that he was unable to do so and met the statutory requirements for defense of insanity.
And I can put the actual basis for the offenses all on the record too.
Can we start with file number 24-21878?
Yes, starting with that file, there's a police report from the Lenawee County Sheriff's Department, report number 23-0000372, which is exhibit number 2 of the settled record. According to that report on January 11, 2023 in Madison Township, Lenawee County, state of Michigan, an individual by the name of Marilyn Lopez, who lived at her residence in Madison Township, was present there. The defendant went to the window of her residence and was looking for a female. There was a brief conversation outside. She asked him to leave. He pulled out a flare gun, broke her window with it, caught her curtains on fire, and entered her home from the window. I believe that supports home invasion first degree in that he did enter a dwelling while she was present, and while entering present or exiting did commit second-degree arson. Supports the second-degree arson in that her curtains caught on fire within her living room. So he did willfully or maliciously burn, damage, or destroy by fire a dwelling or its contents, and assault with a dangerous weapon in that she was placed in fear of harm to herself by the flare gun, both from it busting through the window and actually causing the fire.
So he fired it through the window?
He both fired it through the window and broke through the window.
Okay, all right, Ms. Demont, do you agree to that recitation of facts?
I'm satisfied, Your Honor.
Okay, so on file number 24-21878FH, based upon the facts placed on the record and from the information contained in the police report as provided to both the court and to Ms. Demont, the court finds beyond a reasonable doubt that on January 11 of 2023 in Madison Township in the county of Lenawee, that the defendant did commit the offense listed under count 1, home invasion first degree, that he did use a flare gun to break a window and then enter without permission a dwelling located at 129 Store Street, and then upon entry of that did commit the offense of second-degree arson. That dwelling was lawfully was occupied, and the occupant was lawfully present therein. By firing the flare gun, he did cause a fire to start with the curtains and did willfully damage or destroy by fire a dwelling or its contents. So that's count 1 and 2. And then while firing the weapon into the building and in the building, did make an assault upon ML with a dangerous weapon without the intent to commit the crime of murder or to inflict great bodily harm, but it was assaultive in its nature, and therefore the court is satisfied with count 1, 2, and 3, the factual basis, and the court will accept the no contest plea. On that file, has the court complied with MCR 6.302 B, C, and D? Ms. Arnold?
Yes, sir.
And Ms. Dumont?
Yes, Your Honor.
Okay, let's move on to file number 24-21879FH.
This actual basis comes from Lenawee County Sheriff's Department report 23-000-1504, which is People's Exhibit number 2 for part of the settled record. According to that report, on or about February 7, 2023, in the city of Adrian, Lenawee County, state of Michigan, while the defendant was incarcerated in the Lenawee County Jail, he did possess and was observed by Sergeant Van Wert having a toothbrush that was filed to a sharp point for use as a stabbing tool. While he had that toothbrush, he had a confrontation with Corrections Officer Buford, who was an employee of Lenawee County at the jail while he was there. And during that confrontation, he aggressively pointed his finger at her, threatened to kill her and her family, got close to her, and pulled that toothbrush fashioned as a weapon out. Okay. And that would support count one, that he possessed a weapon or something fashioned as a weapon at the jail, and then also committed an assault on COB.
How did he threaten the assault? Did he wave it at her? Did he hit her with it?
He was aggressively pointing his finger at her while he was threatening to kill her and her family, and then he pulled the stabbing tool out of his pocket.
Mr. Mont, you agree with that recitation?
Satisfied.
Okay. All right. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on February 7 of 2023 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense under count one, possession of a weapon in jail, and that he had a toothbrush that had been filed down to create a stabbing tool, and count two, that coming in contact with CO Buford did make threats at her and then wave that tool or stabbing tool at her, which would be deemed assaultive or threat of an assault. So has the court complied, and therefore the court accepts the no contest plea on that file? Has the court complied with the MCR 6.302 B, C, and D? Ms. Arnold?
Yes, Your Honor.
And Mr. Mont?
Yes, Your Honor.
Okay. All right, so let's move on to file number 24-21880FH.
In that file, according to Lenawee County Sheriff's Department, report number 230015077, which is a People's Exhibit number 2 of the settled record for this particular file. On December 28, 2023, in Dover Township, Lenawee County, state of Michigan, deputies from the Lenawee County Sheriff's Office came into contact with the defendant. They knew he had warrants, which they verified, and they attempted to place him under arrest on those valid warrants. Upon arrest, he physically resisted Deputy Jess Petty, Sergeant Conway Linger, and Corporal Keith Forney while they were trying to place him into a patrol car to take him into custody by attempting to pull away, stiffening his body, and kicking.
Okay. All right, would you agree with that recitation, Mr. Mont?
Yes, Your Honor.
So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about December 28 of 2023 in Dover Township in the county of Lenawee, that the defendant did commit the offense listed under count 1, count 2, and count 3 of police officer assaulting, resisting, and obstructing, and that Deputy Conway Linger, Deputy Jess Petty, and Deputy Keith Forney were all present and attempted to take Mr. Burke into custody. They were sheriff's deputy and IDETA sheriff's deputies, and Mr. Burke failed to comply with direct orders from the sheriff's deputies, pulled away, pushed, or attempted to resist his arrest, and therefore the court accepts the no contest plea. Did you do an MC 207 order?
I did not.
Okay. All right. So has the court complied with MCR 6.302 B, C, and D on that file as well, Ms. Dumont?
Yes, Your Honor.
So I accept all the pleas. They've been given understandably, voluntarily, and accurately. The defendant does have full knowledge of his rights. He does have competent counsel. Obviously, this is a case where he pled no contest, not guilty by reason of insanity. So, do you wish me to go through the commitment order at this time?
Yes, Your Honor, we would ask that the court order he be committed to the Center for Forensic Psychiatry. Okay, you got this.
All right.
Okay.
So I'm gonna need you to prepare it, but I've got it. I think your office prepares it, right? I don't know. Okay. So, all right. So Ms. Dumont, I am prepared to go through the commitment order at this time. Are you prepared? Or do you have any objection to that?
No objection, Your Honor. I spoke with Mr. Burke and he would like to essentially be sentenced today.
Okay.
Which is
well, court in this case. Say it again. What, Mr.
Which is essentially just being committed to be evaluated at the forensic center, but he's
All right. So in this case, the defendant has pled no contest to not guilty by reason of insanity. So therefore, it is ordered that the defendant is committed to the custody of the Center for Forensic Psychiatry for a period not to exceed 60 days. The center shall thoroughly examine and evaluate the present mental condition of the defendant in order to reach an opinion on whether defendant meets the legally established criteria. Wait, might have gone on. Hold on. Oh, yeah, no. Whether the defendant has met the legally established criteria of a person requiring treatment or judicial admission within 60 days from the date of this order. The Center for Forensic Psychiatry, I'm all stuffed up, so I can't speak today, shall file a written report with the court, defense counsel, and prosecuting official in accordance with the mental health code. If defendant is subsequently hospitalized as a person requiring treatment or by judicial admission as defined in the mental health code, defendant shall not be discharged or placed on leave without first being evaluated and recommended for discharge or leave by the Center for Forensic Psychiatry. The defendant shall transport the defendant to the Center for Sheriff shall transport the defendant to the Center for Forensic Psychiatry. The clerk of the court shall send to the Forensic Center for Forensic Psychiatry a settled record of facts concerning the offense which defendant was found to have committed but pled no contest to, not acquitted. The clerk of the court shall send to the Michigan State Police a copy of this order. The Michigan State Police shall enter this order into lien in accordance with MCL 769.16B. And I don't think there's anything else we need to add to that order. Okay.
And in Monroe, we did the other orders, but we didn't do that order, so I'm not real familiar with it.
Okay. I don't know who typically does it here. We don't, I think we do them once a year, maybe. All right.
Yeah, there just aren't that many of them.
Yeah. So Mr. Burke, at some point you're going to receive contact from the Center for Forensic Psychiatry, and more likely than not, you will be moved to the Forensic Center. I volunteered for years there. It's a nice facility. So I wish you the best of luck. Anything else we need to place on the record, Ms. Arnold?
No, Your Honor, we just asked the court to send the settled record to the center for all three files with the order.
Okay, we will do that. All right.